also in the line you quoted about economic harm, that had to do with the fact that they didn't intend, through their testers, to rent an apartment. And so there was no economic loss to them or gain to them from renting the apartment. But what I think the SG is pointing to is that they provided services on their own. It wasn't just the members' services that they were relying upon. They were providing services to people to help them rent apartments. And so that's a very important distinction from here, separate from the individual defendants' claims of standing based on wasted resources, their resources. The organizations are not losing anything. Their job is to do exactly what you're talking about, and they're doing it. They're investigating certain problems, but that's not an injury that's redressable by this, by vacating this rule.
So a couple of things, Your Honor. This court's opinion in Havens did not rely on the economic nature at all. Again, I'd point, Your Honor, to the line in Havens where the court says the non-economic nature of respondents' interest in housing. They were speaking broadly. Again, you have to dig to the underlying briefs to find that economic interest that this court did not rely on. With respect to our own injury, it's absolutely redressable. For example, if the regulations are put back in place, the protections whereby individual abortion providers need to provide information about adverse events, that would provide our respondent organizations with more accurate information about the harms from abortion drugs.